given to me by land use, and I know of no changes.
Right.
Yep, the maps are there,
Yes.
so that you can take a look at them. But again, this is something that we thought was important to bring to the selectmen. Are you ready for the question? Okay. Was there a motion made yet? I don't think there was, right?
So moved, waive the reading.
Brian, second by Ben.
Yes.
Discussion. Brian.
Yes. I'll speak up.
Fred, did you have a comment?
No, I seconded, we didn't have a second.
Oh, Ben second.
Oh, okay, all
Yep.
right.
Thank you. All in favor?
Aye.
Aye. Any opposed? Any abstentions? Motion carries unanimously. The next item, we had, I thought, a very good committee meeting of Sidewalk Tree Committee, and I'll turn it over to Fred and Mike, who were at the meeting. There is before you a suggestion to set a public hearing for rescinding the ordinance, Chapter 17, Article 3, Division 1, a portion of the sidewalk ordinance. But I thought I'd open it up to Fred. Did you have any comments, or Mike?
I'm gonna let Fred talk.
Okay.
He's already talking
Yes,
today.
the co-chairman can also speak.
Oh, I will. I'll
Sure.
jump in at any time.
Yeah, no, I think, as we all know, this has been a topic that's been going on for a long time, and as one looks at it, having an ordinance on the books, and I think we go back to 1934 or 38, an ordinance that hasn't been enforced in Lord knows how long, and an ordinance that there doesn't seem to be any appetite for that ordinance to be enforced. There's, to my knowledge, never been a motion to enforce the ordinance. Or discuss it. The ordinance has been discussed, but no action has ever been.
everyone walks on the sidewalk, you're not precluded. It's not unlike a road, as Selectman Foote has pointed out. It's a discussion we've had numerous times here, and when the bond public hearing was held, there was just, I think you might have been there. There was good discussion, and I had said we need to have a public hearing on this so that people need to know what it is the town's policy is going to be. If we're going to rescind this, it doesn't mean we're not going to pass another one, another ordinance, or another policy, or another methodology. So, it makes sense to revisit ordinances, and if it's appropriate to rescind, to do so, and then proceed with an alternative.
Thank you.
And I only say it should be rescinded, I guess, because in my opinion, and I have not done a tremendous amount of legal research, but it seems like it is legally unenforceable. If you actually asked someone to do that and they said no, and they went to court, I think they would win. But then we had an opinion from legal counsel, who I believe has said the same thing. So that's the reason why I say it's not enforceable.
Any other public comments tonight? Okay, under informal discussion, I just wanted to remind the selectmen and the public, I shared a press release that came out of the Council of Governments that talked about possibility of the Elmcrest site and getting some assistance from the COG, the Council of Governments, in crafting a different incentive that may be appropriate for that particular project. We did have a meeting, as has occurred last Thursday. It was myself, along with the economic development consultant, and Elwin Guile was there as EDC chairman. But more importantly, there were 3 planners from the COG who hadn't heard all together a lot of the information that we shared, along with Mr. Bertram, who is from BRT. He did give us a copy of alternatives, 2 alternatives. One would be an 830G application, which has over 500 apartments that would be placed on that property. And the other alternative is what's called an incentive housing option, which would be a little over 400 apartments on that site. Those latter 2 are certainly, my opinion, unpalatable. It's not something that would be appropriate for our town in terms of impact of services, as well as it's totally not in keeping with the Plan of Conservation and Development, which was recently passed. So the third alternative is something we've already looked at, and the incentive agreement that was placed in front of this board failed 4-3, and we would like to revisit another potential incentive agreement to see if there's something that would be agreeable with the help of the Council of Governments. So they've been of some assistance to us. They've done these agreements before in other parts of the state and in other parts of the region, so I felt that it would be helpful to have them with us. I would open it up to other selectmen if they'd be interested in helping put this forward before there's any application that goes forward. Our timeline is about before February 1st. We would hopefully have something that would be a viable alternative for us to discuss. Is there any interest by the selectmen? Fred is interested?
Yeah, that would interest me.
Yeah, as do I.
Strikes me as somewhat odd that we're going to an outside group to do that when the power rests with the Board of Selectmen to determine for the constituents of the town whether it's in the best interest of the town. It would seem to me that there would just be direct discussions with the developer about any potential incentive, and we've gone through this process once before, where the developer has flatly said that he is not interested in any sort of reduction from a 7-year full tax abatement. So
The law did change in October of this year. It took effect, which the state now allows up to a 10-year abatement period. In the past, the limit was 7 up until October 1st.
that would seem to me to be less palatable to the town, because that's actually more favorable to the developer.
Any other comments?
We only also suggest that there's been the suggestion of a 30G development To me, I don't know that it makes much sense from a financial standpoint from the developer's perspective. This is a prime piece of property, and if they wanted to do 30G, they would do it on another piece of property that's less valuable. So it seems like an empty sort of suggestion that he's going to do such a thing unless he's getting tremendous taxpayer benefit from the state or from some other source.
Any other discussion?
The format for this would be what, Susan? A series of meetings with all of the stakeholders.
I would anticipate not a series, but at least a couple, should be.
And again, I would leave it up to the board, but it would seem to me that if there's going to be a negotiation, that sort of format doesn't work. There was a discussion about the Board of Selectmen in its entirety having that sort of discussion with the developer. I think as a practical standpoint, you get nowhere. And I think if you're going to expand that group and make it even wider, that's just not how things are done. I don't think you can ever come to any sort of agreement. I think the more appropriate approach would be for a representative from the board, most likely Susan Bransfield, to have direct negotiations with them and bring it back to the board. That just seems to me to be the most practical way to reach any sort of agreement, if there is an agreement to be reached.
I concur.
I was just, as you were saying, I was just trying to think back to a prior discussion we had where the suggestion was to get more, I thought it was, I may be in wrong there, but to have several members of the board engaged in the process. But
There was that discussion. I don't know that I believe that that's, so I think the idea was to limit it from 7 to a smaller group.
Yeah,
To me, it makes more sense, and I don't care if it's Susan or somebody else, but
Yeah.
to me, it seems to make more sense that there's, essentially 2 people in the room and having a discussion. It's going to be very hard to iron it out. But, I mean, what are you going to, you're going to have a public meeting, and you're going to negotiate, and one person on the board is going to say one thing, and he's going to read that to mean one thing, and someone else is going to suggest something else. You're just asking for trouble. You're never going to get any sort of agreement in that format, in my opinion.
By agreement, you say agreement between
The developer and the town, if there's such an
between the
agreement
town
to be
as a
made.
whole, but not necessarily between the group working together. If you have 4 or 5 people working, I don't think there could be a meeting of the minds with a proposal.
Well, to me, it's a negotiation, so I don't think it helps to have 5 or 6 or 7 or 8 or 10 people on one side of the board having that sort of discussion. I just don't think it's helpful whatsoever. I think it's harmful to the process. But that's just my opinion.
Anything else?
So where are we with this? Is it in effect, or do we need to have a motion, or what do we need to do?
I don't know that there's a need for a motion.
Okay.
I mean, in essence, it's typical that my office would speak directly with a developer. It's not uncommon to then at least share that kind of information so that we have something going forward, if that's the will of this board. If you want nothing to occur, you can also say that. I mean, we're trying to, as we've stated publicly, the redevelopment of that property is important to the town, and I think it's important to proceed if possible. There's nothing promised, but certainly if there's nothing ventured, there'll be nothing gained. And I think it's very important for us to continue to proceed with the redevelopment of that property that is in keeping and much closer to the plan of conservation and development, as opposed to alternatives which don't follow zoning rules. 830G applications or incentive programs that are available under state law. It's not something that the town of Portland allows to occur, but rather it's a state law that allows developers to come in and then not follow zoning if your town deed restricted housing is less than 10%. In Portland's, like approximately 132 other towns, we're less than 10%. So a developer can come in and request an affordable housing development. The one that Bertram has suggested is over 500 apartments. It's 5 buildings, and it's a potential. I'm not saying that he will proceed. He said that it is something that he's drawn up. I shared the site map, the schematic with the selectmen, and the other is incentive housing, which is a little bit different in terms of the level and numbers of units that would be of an affordable nature, which is a different formula. But that too, as I understand it, would not require that the applicant follow zoning regulations. Whereas the application that could occur with a mixed-use development under the zoning regulations and not under the 830G would have to follow zoning regulations and go through a special permit. That is the one that includes the entire site, that would include a mix of residential, commercial, retail, and also the dealing with some of the historic structures that are on the campus.
So again, I would just emphasize, it's really Ben's point, that to me, if I'm a developer, it would be a financially imprudent decision to put 500 apartments on that property because of the value of that property. It would be much more prudent for someone, an investor, to sell that property or have that property used for another use. If you're going to build 830G units, you're going to do it on a piece of property that's not as valuable as that piece of property. Unless, of course, the caveat would be if you're getting some sort of benefit that changes the balance from the state or from some other source. So if Mr. Bertram is financially prudent, which I assume he is, he's been in business for a long time, that just strikes me as a odd decision if you were going to make use of that property in that way. It certainly is not maximizing the value of that property or maximizing his revenue from the project. And again, I think we've been at this for, I don't even know how long it was, 1.5 years, 2 years. And to me, it seems like, at least as far as I know, there's been no direct negotiations. Perhaps some of that's happened, but it seems like there are a number of players with disparate interests involved in this negotiation, and it's not the Board of Selectmen. And this incentive rests with the Board of Selectmen. It would seem to me that any sort of negotiation should take place through the developer and a member of the Board of Selectmen if you want to get anywhere. I just think if you had 7 people or 8 people or 10 people involved in this sort of process, you're going to get nowhere.
Well, advisors are helpful, Brian. What was suggested is that there be some assistance from the board, since it is a board decision. Typically, when we make decisions, you don't make them certainly in a vacuum. There's certainly committee structure, and information is helpful. If we get to a point where it's a negotiation, depending on how that's phrased, and it's if we're in the middle of something that would be available for the selectmen to review, I think it just makes sense that a couple of other selectmen be aware of what's going on. Not that they're always going to be sitting at the negotiating table, but that they are giving counsel and information. And then when it comes to you, you're not, oh, this is a brand new suggestion that I hadn't heard about. Rather, to know a little bit of knowledge, as we do in
Sure,
a lot of topics.
But it would seem to me that this is only a negotiation. I mean, that's what you're talking about. What else are you going to do? You're going to, I don't know that anybody really
Sure.
needs advice so much from some outside board.
Well, there are other potentials, whether or not there's other financial opportunities out there. I had mentioned some previously in terms of some of the other opportunities that are available. We are going to be having, probably in January, someone that is available to give us some information about incentives and how they're done in other towns, and what laws there are, and some new updates for the law. His name was given to us, I think, a couple of meetings ago, and that would be helpful. Knowledge is helpful. there are other opportunities for incentives and other towns do utilize them, that's of the nature that is helpful.
Susan, just for clarification, don't they need a denial from zoning in order to apply to the Superior Court for the 830G application?
What's on the table at this point, Ben, is whether or not there is an incentive agreement that the town and the developer can reach. If there is, then they proceed with that incentive agreement and the mixed-use development. If there isn't anything, then I can only tell you what they've told me. And what they've told me is one of those other two options would come to an application.
But they told us they weren't interested, or at least Bertram told us they weren't interested in low-income housing.
I'm telling you what I learned last Thursday. That's what he told me, and I gave you what information I had. And I'll make it available to anyone, made it available to the press, so they had it as well.
So at this point, I feel, via the emails where saying you sent out this last information. I'm surprised to see this back. I realize it's different than what we had voted on. But I think, I understand knowledge is a wonderful thing to have at your beck and call, but it sounds like even the first steps, the next first steps coming up would be of a negotiation sense rather than gleaning more information. And I think you're best suited to do that and keep us in the loop.
Are you interested? I hear that you would like me to do that. I know.
I think it's probably some good information to hear. The other part of it is this was before us and decision was made. I'm surprised, as Brian is, and I guess Ben said it too, to see Mr. Bertram back, because he had indicated clearly that he wasn't interested in anything other than his original plan.
I would say that I'm not necessarily surprised that he's back,
Yeah.
but that is what he said. That's
It is what he said, yeah.
represented, Sure. Because this, in his mind, is a negotiation, because he was presented with information from day one, essentially, that he was going to get, certainly seemed to be the implication that he was going to get a 7-year, 100% incentive. And if a developer feels that he's going to get that, he's going to fight for that. And that's exactly what he's doing. So now he's coming back to negotiate, and that's why he's suggesting 830G and other types of housing. Because he's trying to get his 7-year, 100%. Which again, I'll just emphasize that maybe he goes forward with this development, 830G on that property, but it is financially imprudent to do such a thing. It would be so much more valuable to do it on another piece of property. So if I'm in his shoes,
He doesn't own the property.
if I'm in
I
his,
just want to clarify,
fair
that's
enough,
owned by
fair
Fred
enough,
Hesson.
fair enough, sure. But if I were in his shoes and I wanted to develop that type of development, I would buy another piece of property in town for a hell of a lot less money, and I would develop it there, and I would sell this other piece of property, and you'd make millions of dollars more. So I don't know that, if that's the road that he wants to go down, then I don't know that you want to get necessarily in bed with someone who's making those types of financial decisions. He also represented to us that this development would not make any money unless there was an incentive given from the town, and that scares me, quite honestly, because what you're going to end up with in 7 years after this incentive goes away, the property, if he's telling the truth, is going to be useless, and it's going to get boarded up at some point because there's not going to be any money to be made. So I just don't want the town to go down that road.
And in all fairness, Susan, I don't
Yep.
think Bertram owns any real estate, but just to point out Brian's point.
I don't think so.
Just in listening to the conversation, my position is that, has been, and you probably know, that I feel very strongly the town needs appropriate development to alleviate future tax burdens. I mean, we really have to have some development, and it has to be appropriate. And it doesn't matter to me who does the discussion, but the fact that people are willing to sit down and talk about the topic again, of Elmcrest, and try to come up with something that makes sense for the town, I think is really important. I don't think, if we don't become somewhat aggressive, think back to some of the discussion, Mary Dickerson, our consultant, coming in and saying, she talks to other developers and they say, the town is not a business-friendly town. I mean, it's hitting us right in the head with a 2x4. That's an image we have from at least some developers. I know not all developers, but from some developers. So incentives, we don't really get to pick and choose too much with who the developer is. We might have certain opinions about a particular person, but you work with who you have and you try to come up with something that's in the best interest of the town. And without incentives, the likelihood of something happening in terms of any major development is not very promising. You look around the state, place after place, there are incentives. They come in, that's part of the game. Whether we like it or not, it's a reality. And if the town's going to be better off with some development, I think we have to look at it and be somewhat aggressive about it. That's my position.
So Fred, I think everyone is in agreement that there can be a discussion about this. I think it's just a matter about the way you go about doing it. And again, I don't know any town who would have 7 or 8 or 10 people on one side of the room negotiating this. You're just asking for trouble. If you do that, you're not going to get anywhere. And I don't believe that incentives are right in every situation. A similar situation would be what we heard about in Indiana with the tax incentives that the state was giving Carrier. I think anybody can look at that and say that's just terrible policy, and you're just asking for more trouble as you go down the road. This is very similar, but it depends on the development that you want. And quite honestly, there's going to be some developments that are going to come to town regardless of whether you're given incentives. So you really don't want to give taxpayer money away. So that's how I look at it. But I think if you want to have any discussion, it needs to be singular, really, on this side. And I would suggest that Susan Bransfield be the point person on that. My opinion is that's how it probably should have happened back in the day. Instead, you had all these different groups involved and having conversations with the developer and having different ideas as to what was going to happen, and I think that just causes some confusion and makes it less likely that you're going to come to any sort of agreement.
Just want to point out that there was a meeting where this board did not want me to be negotiating. And I vividly remember that, and you...
I think that the distinction is that the board did not feel that it was, didn't feel that you should have the power to make the decisions,
Okay.
which is a big distinction between your being the point person in negotiating, coming back to the Board of Selectmen, and letting the Board of Selectmen decide it, which, quite honestly, I think is the only legal way that it could be done, because there was a state statute that permits, that gives the powers, enabling statute that gives the power to the Board of Selectmen and doesn't allow us to give it away to one person.
Which
So-
I'm on the record for saying would always have been done. I just want to point that out. And I'm on the record for that previous couple of years ago when we talked about it.
I understand,
So
just
want that for
clarifying
the
that
record.
I never said that you should not be a person who would negotiate. I just felt that the power should be with Board of Selectmen.
I do remember a conversation, and there was discussion, albeit not a final decision, but there were members who said that they wanted to be part of the negotiating.
I agree with you that too. I think that's a mistake for the reasons I stated.
Yep.
I think you're better off having one person do that, have those conversations, and that's just how negotiations are done every day, whether it's this or some other thing. You just don't want a number of different viewpoints coming at somebody on the other side and them
Sure,
getting
but this
confused or having
board-
different expectations.
You personally, and I don't hear it from everybody, Brian, but I appreciate you giving your input and guidance to how you want to proceed, because from my seat, there has been mixed messages from this board as to how they wanted to proceed with an incentive. So it's helpful that I hear directly. Because yes, certainly, when it comes to union negotiations, collective bargaining agreements, our process has worked well, where my office, along with counsel, legal counsel, proceed with negotiations and then bring them to you. And when they get stalled or there's a question, we bring it to this board. What I also need to determine, in terms of this kind of a negotiating, if it is something that is allowable under executive session, because FOI, Freedom of Information laws, are very strict as to what you can talk about in private session. So I'll need to find that out.
I would just also say that you're going to continue to have mixed messages from this board, I would anticipate, if this is done in public, because you're sending the message to the developer, and he's hearing these things. Who in their right mind would ever, have one unified message and say what you're going to do, and the developer knows where you're coming from? It just doesn't make any sense.
I'm talking about, no, clarification. I'm talking about methodology. I'm not talking about substance. I'm talking about methodology. If the board wants me to meet with him and engage and bring back to you, that has never been clearly articulated. And in the past, you indicated you didn't want me to do that.
Well, I would clearly articulate that I have always felt that the best approach would be for one person to negotiate. I still believe that that's the best methodology.
Okay.
If you're
That's
going
helpful.
to have some discussion.
That's helpful.
I think the more people that you invite into the negotiation, the more likely it is that you're going to have mixed messages on both sides, and you're going to get nowhere.
But I can tell you, and I think you would agree, you may need to get information from other people. They don't necessarily sit with you in a negotiation, but in terms of information, it's helpful to speak with others that have done this before.
Yeah, although I think the main information that you need is the financial impact that it's going to have on the town, and the likelihood of this project being successful. I think those are the two main issues that should.
Is this board interested in me proceeding to engage with Mr. Bertram in terms of a potential negotiation, in terms of an incentive?
Go ahead, Michael. Go ahead.
I'm very interested in that. A couple things I wanted to say, because I've been listening as well. One of the fallouts of the last vote we had about this, I found very interesting. I just want to share it with the board, and why I'm very interested in having us look at all the options available. There was a great deal of surprise from a number of people in town that it didn't pass. There's a great deal of, at least I found a great deal of consternation about why, especially the people that had really championed and wanted to do something with that piece of property. But more importantly, I found a lot of people that were against it had information that I had no idea what they got. They were against it because they thought there was going to be no taxes paid on the property whatsoever, and that wasn't true. And there was a list of a couple other things too that that were driving a lot of things. So I think there was a great deal of partial information out there that tainted a number of people to the project based on just the contentious nature of this. I get it's small town stuff, but it's a big deal because that property is such a prime piece of property. But so given that, and given the vote that's happened, but given the importance of that piece of property, first thing you see when you come into Portland, and the fact that it is Fred Hassan's property, he can do what he wants to with this property. We don't own it. He can pick any developer he wants to. He's picked Dan. So we kind of have to play in his basketball court with his ball and do the best we can with what we have now. But I think we should, and I fully encourage Susan, you to pursue and look at all the options available. Maybe there's additional state incentives that will augment the concerns that some of the other board members here have about giving, everything away, for the 7 years and whatever that means to some people.
The issue is, oh, sorry.
No, but I think it needs to be looked at. I also think too, if we're honest with ourselves, on the night of the vote, I think one of the things we voted on was, we want to do further discussion, to do some negotiation, and I guess what I'd ask my fellow Board of Selectmen members to think about is, if there's some serious interest in doing something with the property, we need to, kind of look at that, or if we're viewing this as more of a delay tactic and we're never going to vote for something, if nothing is going to be palatable ever, then I wouldn't want Susan to waste her time. But I just think that we should investigate all options. It's just too good a piece of property, and the tax burden in town needs to be reduced for the folks that own homes and pay taxes in town. And as one of them, that's just not something I think is sustainable and will affect us more in a negative way. That's it.
Thank you.
That's right.
I was ready to pass that one.
Anything else?
So from a clarity viewpoint, did I hear that there is kind of unanimous support for you to do the negotiation directly? Is that what just so I understand?
I've heard from 3 people.
I concur with
It would
Brian.
seem to me that the appropriate way to do this would be Susan to do this, probably with advice of council present, and have those discussions. And
So-
we can certainly start off with a framework and go from there.
So we can infer that, as Michael stated, this is not an exercise in futility, but rather an exercise that would be entertained by this board.
I don't have any idea, because the last representation that we had from Mr. Bertram was that he wasn't interested in anything. So I don't think it's a waste of time ever to talk to a developer who comes in.
Okay.
It's just a question of what's discussed and what's good for the town, and you make the decision. Which I think we've sort of,
So along those lines, I think it might be, one of the opening questions you might have is, does Mr. Bertram have any more flexibility than he had announced at our last meeting with him?
Okay.
I concur with Kitch and Brian's position.
Thank you, Ben.
I agree, but I think we need to see really where he is coming from, because that night he said he had no more interest in working with us at all. So, does he really have interest now?
All right, I'll do my best. Anything else? It's just under informal discussion, so I will keep you informed.
Susan?
Yes, Kitch.
Could you give us an update on the status at 484 Main
Yes.
Street?
We talked about this. This is a property where they have been parking in front of their house on Main Street.
On their
which
front lawn.
is on their front lawn, which is in violation of zoning. And a letter went and identified the fact that they were out of compliance with zoning, and they had 30 days to comply with zoning. Our land use administrator told me today that she took a photograph and showed that they were continuing to park, and they were not in compliance with zoning. So Dan Beret, our zoning enforcement officer, will be issuing a cease and desist on Friday, and then that takes its course as far as appeal rights that the homeowner has, and we'll see where we proceed from there.
If the violation continues under the cease and desist order, do we have fines? Do we fine?
We do not have zoning fines.
Okay.
We do not. What happens is it is appealed and typically, and that typically would go in front of the zoning board of appeals, and then if they are not in agreement and the homeowner wishes to continue, then they go to Superior Court. And then we would have to go to court on the matter. We've done this before and for zoning violations, and that's where the dollars come in.
Yeah.
I think I'm
For
missing.
both parties.
I think I might be missing something. So we tell an owner of property that he can't park in his front lawn, and there's no teeth to that, so
I didn't say there's no teeth.
that's why, maybe I misunderstood.
We
So-
don't have fines, Brian.
Yeah.
And one of the reasons we don't is, as I understand it, zoning enforcement officers in Connecticut law can be held liable for those fines,
Yeah.
personally liable. So we don't issue fines, but what we do is a cease and desist. If they don't proceed appropriately, then there's court action that can be taken.
What type of,
I would have to talk to Carrie about that. I know in the past, what's more typical is that they appeal to ZBA. I'll tell you something that happened very recently. They appealed to ZBA, they upheld the town's order from the zoning enforcement officer, and then the homeowner appealed to Superior Court, and the town went to court, and the town prevailed. And now we're in the process of having the property owner come into compliance based on This was an engineering and public works matter.
I guess I'm just asking the question more out of curiosity. It just seems to me that why would the landowner appeal this if there are no teeth? That's so you cease and desist, you can't do it, he continues to do it, et cetera, et cetera.
Then you can take court action. If he doesn't appeal it, then I would go to our town attorney and proceed. But as I understand it, then there would be other legal means that would be taken. But I'm not an expert on it. I'll get back to you.
No, I understand. It just seemed to be logically, I couldn't figure out why someone would actually comply or file an appeal.
And frankly, fines aren't always, as we found in some of our blight matters, they're not always effective either. What seems to be effective and what has occurred in the past in other instances is more court orders that they must comply, and then the court imposes particular penalties, and I'm not privy to exactly what they would be.
I'm just curious.
That's how,
Sure.
it typically ends up going to court. And that seems to have more teeth than fines, which are in the blight ordinance. In the zoning ordinance, we don't have. Anything else? Any other questions? I have nothing to add, other than, I think you may have in your packet some comments that, were made in regard to, yes, in regard to the ethics ordinance as a follow-up. Bruce Tyler sent to me, and I'm shared with you, some comments that he had on the ethics ordinance. And I also shared with you something that will be on your agenda in the future. There was a water service break at Chatham Court. And when the town turned the water back on, there was damage in the apartments, and they've asked us for consideration for paying the fine. Some of the Public Works Director does not believe we should pay it, but I thought as the Water Authority, it should be brought to you, and we can discuss this at a later date. But I wanted to share this with you. The total bill is $1,917.32, based on damage that occurred based on the water being turned back on.
If I can, I'll just reiterate my opinion about the ethics ordinance. I think it needs to be revisited. I think it needs to be altered in some way, if not thrown out in its entirety. I don't think it's a document that is workable.
You know, and as we're doing with the sidewalk ordinance, Brian, one way to do that is to rescind what's on the books and then work on a replacement, rather than taking what may have certain areas you don't like, and you start jerry-rigging it a little bit, and then you end up with an ordinance that might not be as well developed as if you set it aside or you put it as a moratorium, and state that as of a certain date, you will have an alternative placed in its stead.
Either way, I think that, just for people in the audience, I think the history of this was that there was obviously a problem in the past that needed to be investigated by the Board of Selectmen.
Before this board.
Before this board of the first Selectmen, and some
Before this first
activities, before you have nothing to do with it whatsoever. You were probably on the board at the time. But
No, I wasn't.
You were not.
I was off.
An ethics ordinance allows subpoena power, so
Right.
there was not an ethics ordinance at the time, so the board was not able to investigate what was going on. A lot of time went on, statute of limitations expired, so I think there was a calling to have an ordinance, an ethics ordinance, so if the town were facing that situation again, we would have the ethics ordinance that would allow us to investigate any improprieties that were going on. I think when we formed the commission, that ethics ordinance kind of took on a life of its own. I think it's kind of a hodgepodge of ordinances from different areas, different parts of the state, different parts of the country, I think. And it just doesn't coalesce, it doesn't work together. I think you're asking commissioners to decide rules of evidence according to this, and it goes on and on and on, and obviously, I think there is a lawyer on there, and he's going to be familiar with the rules of evidence, but other people are not. It seems to me that any sort of sanctions, it's kind of loosey-goosey. The whole thing just seems terrible to me, and I think it should be rescinded. And I would have, I certainly wouldn't oppose rescinding it in its entirety, and then at some point, creating an ethics ordinance that makes sense.
And I also add that every
Because I
year
do think
it
you should
seems-
have an ethics ordinance, I just don't think this one is one that is going to work.
Whether or not the state is ever going to get involved, they always suggest in the legislature that they will have a municipal ethics ordinance that they will enforce. There's a lot of contraindications to that. I don't typically want to have the state involved in every city and town in terms of ethics ordinances. So that is not gotten legs, but it is introduced every year. It's certainly something we'll put on a future agenda, but I thought it was important to point out that there's additional input, and I'll also add that the Ethics Commission itself thinks there's needs for improvements to that ordinance, as does our labor attorney, and as does some citizens that have made comments to us. So it's something we'll need to revisit. That's important, so we'll put it on the next agenda. The last thing I just wanted to let you know about, because I know everybody has cookies that they have to bake, right?
Could we, going back to that, could we put that
Right.
I do.
on the March, because I've got a lot going
March?
on the ethics. I'm talking
Yes,
about.
you want it in
So we
March?
do it, because I think I put it on a year or two back, and I know we have talked, I generally agree with what Brian's saying.
Yeah.
But let's just do it and put it in so we get to it, okay?
Did you have a particular date?
No, but I was just thinking there's a lot going on, so
There is.
if we say March, we're
Okay.
going to deal with it.
That sounds good. It'll be in the middle of the budget.
Whether you go down the road and you appoint a commission or committee to do this, again, it's going to be important that you have the right people doing it, but that's an issue.
And
You can deal with that in March, I think.
Okay, that sounds good. The last thing I wanted to let you know, I think I told you that the town had applied for a sidewalk grant through the Council of Governments, and it's the 2016 through 2021 Transportation Alternatives Program. 6 towns applied. Portland came in second. We were beat by Haddam. Damn. And they had a really good plan. It's also a sidewalk plan, and it is, they got more points, they got 1 more point above us. And it was, and I agree with the committee, and it had to do with safety. If everyone's familiar with the swing bridge, they're redoing the swing bridge, and they're gonna have a sidewalk that will go from East Haddam into Haddam, and to get up into the Tylerville section, there's a need for a sidewalk. So what will happen next with this Transportation Alternatives Program is the top 3, so it's Haddam, Portland, and Essex. Those 3 applications that ranked highest will now go to the state committee, and then the state committee will determine which of those from all of the councils of government in the state will get funded. Now, let's say we're lucky and we get a couple funded, we'd be second in line, if only 1 gets funded. We'd be next in line for what's called the LOTSIP program, which is Local Transportation Capital Improvement Planning. So we're in the queue, and I think that's a good thing, and we were ranked fairly well. So going back to our discussion of sidewalks, I think it's important to have a program for improvements. You're not going to do all the improvements in 1 year or 1 season, and if we're able to proceed with the bond monies that we have for the new sidewalk money, then in a couple of years, if we get this grant money, we'll already have some of the establishments as far as how we're going to improve sidewalks, and we continue that program and continue to make improvements.
Susan, would you talk a little bit about the rating of our police department?
Oh, yes. I sent out an email, and it was a good news item. I think it's Penguin Insurance. And they ranked various size towns in Connecticut, large towns, medium-sized towns, and small towns. Portland was ranked one of the 10 best and safest towns, I would say, number 7 for small towns. And in terms of all the towns that were ranked, we ranked number 11. So we did very well, and I would like to applaud our police department for the work that they do. And thank you. We happen to have 2 officers, Lieutenant and Officer Licio here. And I also want to thank our community that I think values public safety and values our police department and knows that they are helping us remain safe in our community, and it's proven by the statistics. So thank you. Thanks for mentioning that, George. If there's nothing else, I have nothing for the executive session tonight. There's nothing new. So if I'm correct, I think we can adjourn. Is there a motion to that effect?
So moved.
Seconded by Kathy. Yeah, I mentioned that at the beginning of the meeting, the draft resolutions for your consideration. The recreation draft. Thank you.
I know.
What course are you taking, girls?
You made it through.
Feel better? I don't remember, I disagree with you about something.
I know.
That's why I like it.
That's why I like you. That's why I like you.
I
You
figured
dis- you
that.
you disagree passionately with logic, I like that.